The hearing session is now open. Forms part of the examination of the Waverley Local Plan Part 2. My name is GJ Fort and I am the inspector appointed by the Secretary of State to conduct the examination and to report to the Council in due course. The format of the hearing is a structured and focused discussion that I shall lead. Before we continue any further, if I could ask the representatives of the Council to introduce themselves, please.
So yes, good morning. Wayne Beglan, counsel for the Local Planning Authority, and with me today I have Mr. Ellis and Miss Dove.
If I could invite those joining us on Zoom to introduce themselves, please, starting with Mr. Smith.
Yeah, I'm Ray Smith. I'm here on behalf of the Showman's Guild of Great Britain, London Home Counties section.
Thank you, Mr. Smith. And Ms. McDougall.
Hello, I'm a local resident and I'm very concerned about Badshot Farm Lane being a public footpath. So this is why I'm here.
Okay, thank you, Ms. McDougall. We'll pick that up further on in the session. So now would be a good time to switch off mobile phones or turn them to silent. The programme officer for the examination is Charlotte Clancy, who should be the main point of contact prior to and after the hearing sessions and should be copied into all correspondence. The hearings are being filmed and live streamed. Is everyone present on Zoom comfortable with that? Mr. Smith? And Ms. McDougall?
Yes.
Thank you. So the matters to be discussed today will be focused questions based upon and taking forward the matters, issues and questions and associated written statements received. I am tasked with considering the soundness of the plan in accordance with the criteria of the National Planning Policy Framework and also whether it is legally compliant. The hearings are intended to assist me in that regard. In submitting the plan, the Council considers that it is a sound one and this is the starting point for the examination. So if you are challenging the soundness of the plan, then you have to explain why and what changes might be necessary that will make it sound. I have read and will take into account the hearing statements that have been prepared and also the original representations that were made. So there's no need for these to be substantially repeated. Instead, the aim is that the discussion moves on from those documents and deals with specific questions that I have or areas where specific clarification or explanation are required. At times, I may ask for a more general contribution or a summary of your position. And when contributing to discussions, it would be helpful to me if contributors would stick to the matter in hand and refrain from commenting on unrelated matters. In order to test the plan for soundness, I will need to ask questions. So you will have seen that I have already been doing this in preliminary questions and correspondence with the Council and in the published matters, issues and questions documents and in other hearing sessions. And both the Council and other participants have responded to these. The questions will continue today. However, anything that is asked should not be taken as demonstrating a particular predisposition on my part. I will normally start a particular topic by asking the Council for responses to questions I have before indicating that I wish others to comment. For those joining us on Zoom, if you wish to contribute, if you could indicate that you wish to do this by using the hands up function on the Zoom program. In the course of discussion, if you wish to highlight certain parts of your statement or other documents that form part of the examination, then it will be helpful to me if you can provide the references. So those joining us on Zoom will have to make sure that they are unmuted when speaking to me, but muted at all other times. If any of those joining us on Zoom experience technical difficulties, they should make contact with the programme officer in the first instance. It's open to the council to propose further changes to the plan, and I would ask that they keep a record of possible changes that arise during the course of discussions. Any changes that will constitute main modifications will be subject to future consultation. The examination remains open until my report is submitted to the council. However, no further representations or evidence will be accepted after the hearing sessions have finished unless I specifically request otherwise. Moreover, I am not expecting any further written submissions during the course of the hearing sessions, but I may request further material should discussions indicate that that will be useful. There will be a short session at the end of each sitting day to ensure that any suggested modifications or additional items such as topic papers or other evidence that I might request suggested during the course of discussions have been adequately recorded. Are there any questions at this stage about any of the procedural aspects of the hearings? Okay, in that case, we'll move on to the substantive discussion today. Just a note, if it does get hot, please take your jackets off if that will make you feel more comfortable.
Thank you, sir.
So we'll now move on to the substantive topics under discussion today. So which is the local plan part 2's approach to the provision of traveller accommodation. So by way of introduction to this topic, I'd like to invite the council to outline in broad terms whether the plan's approach in these terms is justified, effective, and consistent with national policy. It would be helpful to me if you could outline any proposed main modifications in your response and the reasoning for these. Thank you.
So the council's approach has been to take the lead from Gypsy and Traveller site allocations and their provision from the policy in local plan part 1, which is ALH4, and that sets out the strategic approach to Gypsy and Traveller provision within the borough during the plan period, and that policy includes a sequential approach to the allocation of Gypsy and Travelling Show People site, and specifies that those site allocations will be dealt with through local plan part 2. In addition, local plan part 1 was supported by the Gypsy and Traveller accommodation assessment, which the council has continued to use during the preparation of local plan part 2. And it forms part of the evidence base for both of those documents. In terms of seeking to meet the need for Gypsy and Traveller accommodation during the plan period, the council has taken into account the planning permissions that have been granted more recently. So the Gypsy and Traveller accommodation assessment had a base date of March 2017. Obviously, local plan part 2 has a base date of the 1st of April 2020. And so the council has sought to ensure that the more recent planning permissions that have been granted for additional Gypsy and Traveller pitches in that intervening period have been taken into account when calculating the number of pitches that need to be allocated for in local plan part 2. The council, in terms of its calculations, has set out how we've arrived at the figure in our topic paper for Gypsy and Traveller accommodation, which I hope has been submitted to you. And then in terms of choosing the site allocations, the council has used the sequential approach set out in ALH4 in local plan part 1 to seek to allocate sites which represent an intensification of existing Gypsy and Traveller sites, with the exception of the Burnt Hill site, which is a former travelling show people site. But in that site allocation, we're proposing to reuse it as a Gypsy and Traveller site. The council has had regard to the guidance in the MPPF and the MPPG, together with the planning practice, the PPTS as well, in terms of drafting local plan part 2. We are proposing to include some main modifications to the Gypsy and Traveller section of local plan part 2. And those main modifications firstly relate to the suggestion to include an additional policy in that section relating to general layout and design of Gypsy and Traveller accommodation, to ensure that it meets, it's adequate and is of a good standard and doesn't compromise living conditions for those inhabiting those sites. And then the second modification is in relation to the Old Stoneyard site, which is a draft site allocation, which, as you I'm sure are aware, has been the subject of a recent planning application for intensification, which was refused at a planning committee, and therefore the council is proposing to reduce the overall yield on that site to reflect the fact that planning permission was refused, mostly on the grounds of layout and design, to try and address those reasons for refusal, though I appreciate that that site would need to obtain planning permission before any changes can be made to the yield on that site. I think in summary that was all I had to say. Was there anything you wanted to say?
So just to add that some of the modifications that we're proposing with regard to the site allocations also include some additional text to the allocations in Farnham, where it's been assessed that there be likely significant effects on the Thames Basin Heath SPA, and therefore there's an inclusion of a requirement for that to be mitigated through the measures that are being put forward, the strategic solution put forward, which is suitable alternative natural green space, and obviously contribution to strategic access management and monitoring. So those modifications apply to DS17, which is MM27, DS18, which is MM28, DS19, which is MM30, and DS20, which is MM31.
Thank you. So we talked last week about the base date for housing provision being updated to, being proposed to be updated to 1st of April 2022. So in terms of consistency, is that anticipated that that is what would happen to the Gypsy and Traveller supply position as well? I mean, I note that the in answer to my preliminary questions, an update paper was prepared that was dated March 2022. So we got any views on that?
Yes, yeah, we would be happy to update the position to the 1st of April 2022. That's not a problem at all, sir.
Thank you. So if we can move on to the plan's approach specifically to travelling show people provision. I just wondered at this juncture if I could invite Mr. Smith in. So Mr. Smith, in your Regulation 19 statement, you make reference to travelling show people households that in your view haven't been picked up by the accommodation assessment. Or addressed in the plan. So could you outline your concerns in these regards, please?
Yes, sir. And if you will just give me a couple of seconds to go through the history, because it is slightly historical now. I think it was about the year 1999. At that time, the planning guidance for travelling show people was 2291, produced in 1991 by the then Conservative government. And it recognised that travelling show people had very, very few sites. And a number of boroughs after 2291 became quite positive about planning permission, as did the planning inspectorate. In Surrey, for instance, Tandridge was permission given by the inspectorate after a long fight for plantation. So people were living there. A group of show people, a large group of show people, bought a site in Cranley, Alford. I think it was 42 families, but 21 plots. They were family plots. And they applied for planning and they moved on in advance of planning. And the council took, quite lawfully, enforcement action to move them off. And over several years, they did that. It went to the High Court. The council got an injunction banning these show people from the borough completely. They moved these show people out. Now, in the year 2000, the Transport Committee region undertook an investigation into the state of the fairground business, and they expected to look at fun fairs. But what they found was, from evidence given, that the condition of travelling show people themselves was so bad in terms of living accommodation, there was very little around. And they were very critical, that committee, of the Showman's Guild, who at that time did nothing about it. So the Guild formed a committee. The London and Home Counties section, which obviously includes Surrey, formed a committee of their own. And since that time, no showmen were ever evicted from sites because the Guild would work with them and stop that. Well, that's anyway what we thought. That's the reason. But then, of course, we had 2005 Housing Act. 2006, there was revised Gypsy guidance, and in 2007, we had 0407 for travelling through people. And what was most important was the concept of accommodation assessments, because for the first time, there was actually evidence that could be agreed between local authorities and the Guild about the shortage of space. But then we came to Waverley. And Waverley, of course, had moved all their travelling show people of this, all of them. There were a couple of old plots there, but this group out, and they were spread around. They shoved them out of the borough. So Waverley said, there's no need in our borough. It went to then, we had the regional spatial strategies, we had the examination in public of that in 2009, and the issue of the Waverley show people was raised there, and from two other boroughs in similar positions, where evictions had taken place before the Housing Act, or the accommodation assessment. And that committee, in evidence, because of the 2010 election, it wasn't published, but it was published under Freedom of Information, reached the conclusion that Waverley should take responsibility for those show people and not offload them everywhere else. Waverley actually took a semi-positive view and actually agreed a couple of years later, because I attended, to undertake an accommodation assessment of those families, invited them to the borough and went through I think OOS did it, in great detail as to who was where and when. And what that proved was that a large number of these show people actually were totally and utterly homeless. Now, if you see a group of gypsies and travellers living on a piece of land, that obviously is an encampment. If it's not their land, then it's unlawful. If it is their land, then they're outside planning permission. But that is where they are, and they are included in an accommodation assessment for that area and have to be taken into account. So people do not trespass on other people's land. They never have. They'd be thrown out of the Guild. It's against the rules. But where show people live during the year, they have no other home, is actually at the fairs in which they work. So they moved from fair to fair with the families, with nowhere whatsoever to return to. During the winter months, because there were no transit sites, and so people don't want transit sites, they'll find another showman who's got a bit of space for the winter. They'll go in there. They're not living in that bower. They're like cuckoos in that nest for a short period. So if there was an accommodation assessment done at that time, they would not be counted. What Waverley did, by their action, which was lawful at the time, was they moved these families out. And since then, a significant number of them have never yet found a home. We believe it's about time that Waverley, once again, faced up to their responsibility, do another accommodation assessment of those families so we can establish which of those are still homeless, and then look at them within the borough plans, because they are all stakeholders in Waverley. They still own land in Waverley. They own land nowhere else. The cost of the court action, so people do not get legal aid, because it's considered business premises, so they had to fund it themselves, and they did. Prevented them from looking at buying land anywhere else. They have land in Waverley, and some of them should have the right, in our view, to move back there. It was a huge site. It was an unrealistic site. It was like a village of its own. But nevertheless, there are a group of show people whose needs should be considered by Waverley. Waverley has in the past toyed with that idea. They undertook the need accommodation assessment, and they reached conclusions of those who actually had a need. We believe that should be recognised in Waverley. Waverley should work with show people to find a suitable site, perhaps 2 smaller sites for those people who are homeless. The action Waverley took over 20 years ago. It still hasn't been resolved, and that is not right. Waverley has a duty to cooperate with other boroughs, shoving people out into other boroughs, hoping that they'll pick it up and sort it out in their own plans. That's not cooperation, and it's certainly not fair. That's simply, it's a historic position, and it drags me back 20 years. We thought it was being resolved in 2010. The law changed, and Waverley toyed with it and then rejected it. I'd like them to reconsider that position and look at who of those show people are still homeless. Thank you, sir.
Thank you, Mr. Smith. Have you got a view on how many plots were involved in that site? You mentioned that the action was taken on.
Yeah, it was about 21 large plots. It was a very large site. I would believe we'd be talking about 15 plots now of people who are in desperate housing need.
Thank you, Mr. Smith. So this Cranley site is mentioned in the accommodation assessment that makes reference to it, and I've read your response in the hearing statement, but have you got any views in response to what Mr. Smith has said there?
I think in terms of our approach to allocating land for travelling show people, we've taken the lead from the Gypsy and Traveller Accommodation Assessment, and particularly in relation to paragraphs 1.25 and 1.24, which talks about the individuals who had an interest in the land in Cranley and the fact that they now live outside of the borough. And I think the council's approach has been that we wanted to accommodate the need arising from within the borough. The site itself, you'll probably be aware of the planning history of it, and the council, I think, still considers that the site is not really suitable for travelling show people accommodation. I don't think I've got anything further to add on that.
How many applications have there been for travelling show people accommodation, if you know this off the top of your head, since the adoption of the local plan part 1?
If my memory serves me correctly, I don't think there have been any planning applications submitted.
And in terms of the need that the accommodation assessment does find this for 2 plots, is that correct? But subsequent correspondence, which I appreciate is not in the public domain, indicates that that's probably not necessary at the minute. I appreciate you might not be able to say a lot about that, but in short, what sort of confidence can you give me that that need is no longer relevant?
So the council has, well, as officers, we've been to visit the individual where the need from the GTAA was identified, had a discussion with the individual who lives on the site, who gave us some information about other members in their family, and particularly the younger generation, and their plans for the future, and really sort of outlined that the situation had perhaps changed in the family since the GTAA was undertaken, and that the need for any additional plots was no longer required for that particular family.
In terms of speculative applications, let's call them speculative applications, as opposed to allocations that might come forward, and bearing in mind there's also been the main modification proposed in terms of design standards, which we'll pick up again later. Does that give, do those criteria-based policies give an effective basis to consider any of those applications that might come forward in the remaining plan period?
I think the policy AHN4 in Local Plan Part 1, which sets out the sort of sequential approach to gypsy and traveller accommodation, but also includes some broad design and location based criteria, gives a good steer, I think, for speculative applicants as to what the council would be looking for a new gypsy and travel or travelling show people site. And I think the proposed main modification for the additional policy that sets out the sort of design criteria provides some sort of further guidance as well as to what would be required of those sites.
Anything further to add at this point, Mr. Smith?
Well, yes, sir. Clearly, the local authority need assessment based on those who are in the borough now. The issue is that they cleared people out and issued injunctions against them. The fact that there have been no further applications from travelling show people since that time is because Waverley, by issuing injunction against guild members at that time, were hardly putting up a travelling show people welcome sign. What I would ask the local authority to do is to actually take the ORS survey that they commissioned since 2010 of those who were cleared out of the borough, so say quite lawfully, and identify those as having a legitimate need that is not being met anywhere else. Because otherwise, what Waverley are doing is failing to follow their duty to cooperate. I would ask them to look at that. I'm not saying the Cranley site is suitable, but if those travelling show people who have nowhere else to go would have an indication that Waverley identified them as having a legitimate need, they would be encouraged to actually work with Waverley and look at appropriate sites. The need they've described comes from the who've been there forever. They were not involved in the Cranley site. They're nothing to do with the Cranley site. This is a specific group. It was not a sensible action for them to take 20 years ago, but I guess they were following what happened at the plantation and assuming that that might happen here. It didn't. what we should be looking at is the borough saying that they will have criteria-based policies and they accept that the former Cranley show people have a legitimate need in the borough. I'm not expecting the council to find appropriate land for them. I'm really not. Just to have criteria, because the show people themselves will find land. I couldn't identify the land appropriate for show people because I don't know the vehicle access requirements. That's not my skill. But what I would ask the local user to do is to require that the local authority publish that ORS study, that is a legitimate need. Over the next 10 years, working with the show people could be met to finish this once and for all and correcting it. It wasn't an injustice, but it's certainly an unfairness. Have a 21st century approach to travelling show people, which is that people should have a decent live. Not a huge site, not Cranley. No, because that's not appropriate, but other sites. The council's got a very, as far as I understand, a good positive policy with travellers. You can do that at the expense of travelling show people. You don't turn one section of the community against the other. Not that they're deliberately doing that, but that's effectively how it's worked out. Let the travelling show people accept they have a need, and then work with them to find places where that can be met within the council's own criteria. At the moment, an application from those travelling show people, the council would simply react that they have not got a need in the borough for travelling show people sites. There's no question about that. That's how the system works. But, because there still is from some of those families.
Thank you, Mr. Smith. So in terms of a couple of points there, so we've heard about the criteria-based policy that is in the Part 1 plan, and also there's a proposal for a criteria-based policy more generally in design terms to be put in the Part 2 plan by way of a main modification, which we'll pick up in a bit more detail later. We've heard what Mr. Smith said about the duty to cooperate, so your reflections on that would be useful as well. So if you'd like to give us a response to that, and then we'll move on to some other matters.
Well, sir, yes, but first perhaps in relation to the duty to cooperate, as you know, Inspector Ball considered that, and he considered it through a number of lenses, including the communications that the council had with gypsies and travellers and travelling show people, and he was entirely satisfied at that stage that we had undertaken sufficient inquiries and cooperation to discharge that duty. And so you may recall that in relation to policy AHN4 that your attention has been drawn to, that was initially drafted so that it had a requirement that related to need in relation to the criteria-based policies. And by, I think it was main modification 6, Inspector Bore asked for that to be removed so that there would be parity between the criteria in that policy and the criteria that apply to the settled community in that respect. And so we listen very carefully to what Mr. Smith says, but in relation to whether or not a current need in borough can be demonstrated, that doesn't prevent a speculative application from being made, which if it otherwise complied with the criteria in AHN4 would find favour with the council. Of course, if applicants making applications can, in addition to those criteria, demonstrate that there is an important issue of local need, then that will be a further material planning consideration that the council will be bound to take into account in determining any application. So to that extent, sir, we commend again to you the policy that Inspector Ball, subject to those changes, found sound within LPP1. And of course, what we are now doing is making various provision for elements of the community consistent with the conclusions of the GTAA. And so you recall the conclusions of the GTAA entirely correctly. And of course, the local planning authority can only bring forward its current proposals for planning policies based on the evidence base. And Inspector Ball described that part of the evidence base as being a comprehensive piece of work. within his report. So he plainly considered it and formed that view about it. And to give Mr. Smith perhaps some further comfort in terms of the way matters move forward, as we've discussed in earlier sessions, there will be a review of the strategic policies that have supported LPP1 itself, and that will be taking place by February next year. And of course, as part and parcel of that, the council will have to give consideration to the appropriateness of updating the evidence base, as Mr. Smith has invited us to consider at that point in time. So all of those protections are in place as matters stand. And so we say on those issues of general principle and approach, LPP1 plainly has been found to be sound, and we also commend to you the LPP2 approach, which seeks to take that strategy forward. I don't know if my colleagues have anything further to add on those points. No.
Okay, thank you. So I'll take those views into account as the examination progresses. And as I say, I've got further questions, particularly on the criteria, the design criteria policy further down the agenda. But as I say, I'll reflect on those as the examination progresses. And I've heard both of those points now. So, Mr. Smith, did you want to come back in? Sorry.
Yeah, well, thank you, sir. And I did hear those comments, and it gives me slight comfort. I would hope, and I will come back obviously to the local authority, because I would hope that the ownership of land in Waverley and no other borough will be a factor that the council will take into account. I have never yet found a local authority when receiving an application from travelling show people anywhere who haven't, quite rightly, weighed the evidence of need against what is considered a disruption to the local area. Nobody is going to deny the travelling show people sites, because they are, because brownfield sites are far too expensive for travelling show people and for travellers for obvious reasons, housing demand and so forth. That there will be an area of disruption, and planning applications by local authorities and inspectors were balanced. I would really wish that the report reflects the fact that there has been recorded a need, a request made to the local authority, come back and reassess that need to see how much of that need is genuine. How many of those people are actually homeless and have nowhere else but Cranley where they have a stake? And then that can be considered in a policy. I would hope so that your report may reflect this discussion. While at the moment it is slightly comfortable when a planning application hits a planning officer's desk, and everything changes and we get into yes, no, give it, don't give it, refusal. And I want to get away from that and work with the local authority to meet this genuine need in Waverley from people who own land in Waverley, or stakeholders in Waverley who want to live in Waverley, and not for a huge site of Cranley, appropriate site somewhere in the borough. Thank you, sir.
Thank you, Mr. Smith. So moving on now, I'm going to move on to issue 2, because we've got Ms. McDougall with us, and as she said in her introduction, she has some concerns about the proposed access arrangement for the DS19 site. So if I could just bring Ms. McDougall in to outline those concerns, please.
Hello. Yes, I'm very concerned because it's a public footpath, and that hasn't been said at all on any of the documentation put in. They just call it Badshot Farm Road. Sorry, not even Badshot Farm Road. They call it access from Badshot Road. It's Badshot Farm Lane. It's public footpath 113. It's very narrow. You have to stand to one side to let cars pass. It's just not suitable for any extra vehicular activity. The public footpath should be protected. The original application was for one gypsy pitch, and that was refused at planning. The inspector granted it at appeal because he said it was for only one gypsy pitch. And he also applied conditions to limit the size and number of vehicles and caravans to protect the living conditions of the adjacent occupiers of the land, highway safety, and the visual amenities of the area. I mean, the footpath is a leafy green lane. It joins the green spaces in Badshot Lee with Elizabethan barns, an old kiln, a Stone Age barrow, and then on into the countryside. And it's become a really important recreational route used by many residents and is worthy of being protected from development. I mean, because of the extra housing in Badshot Lee now, the footpath is so much busier. You have the elderly, you have the infirm, you have kids on bicycles. It's just so unsuitable as an access for a site where I'm assuming there will, travellers have vehicles that they want to be able to use, and they should be able to use. They shouldn't be limited to what sort of vehicles they use because it's up a public footpath. It's just so wrong on so many levels. And when I spoke to, was it Planning Officer Matthew Strong, he told me that any future application for the site would need to be supported by a transport assessment to assess the transport impacts of the proposal, including the impact on public footpath 113, and will need to demonstrate that any proposal would not have an unacceptable impact on highway safety. The lane can't physically get these huge vehicles up. When the original accommodation, the mobile home, was delivered, the lane was blocked for over an hour and a half. The ditch was partially filled in, branches were removed from overhanging trees. And the trees are really growing over beautifully now, and I think it would be a great shame for any more trees to be cut down. Thank you.
Thank you, Ms. McDougall. So in terms of this site, I take it from the hearing statement that the County Council have given some views on it. Is that advice available?
The County Council have provided some advice on it. We haven't made the email correspondence available, but I don't see a reason why we couldn't, if that would help you, sir.
And in terms of those points of Ms. McDougall's on the access, is there anything specifically you'd like to respond to on that?
When we contacted Surrey County Council, we contacted both the Highways Department and the Public Rights of Way Department to obtain their views on the principle of additional pitches on the site, and they didn't object in principle to it. Although I note that the details in terms of the design and access would need to be addressed at the sort of planning application stage. Just by way of an update on that site, so the Council has received a planning application in May for additional 6 pitches on the site. It contains both the site allocation but also a small piece of land to the south of the site, which is also included within the planning application boundary. The application hasn't been determined, it's still pending consideration, and having spoken to the development management officer who's been assigned the planning application, they haven't yet reached a view on the acceptability or otherwise of the proposals. It's early days, I understand, in terms of considering the application, and I don't have a timescale at the moment, unfortunately, for the determination of it.
So that, sorry, in terms of the figures of that planning application, is that for 6 in total or 6 additional?
As I understand it, I think it's 6 in addition to the one that's already there.
And in terms of the assessments at the planning application stage of either the pending application or one that sought to increase the number of pictures in line with the allocation. So we heard Ms. McDougall's outline of her conversations and the transport assessment that would have to be provided. But in terms of, there's some other effects there that Ms. McDougall picked up on, like the effects to trees and the sort of infilling of ditches. I mean, might there be things that could be captured in a construction management plan at the planning application stage?
Yes, I agree. I think that that could be addressed at the planning application stage through a construction management plan, and other plans perhaps to show that so any protected areas around the trees and hedgerows and things.
Oh, shit.
Ms. McDougall.
Sorry, I forgot to unmute. Yeah, the entrance at the bottom of the lane is through Squires Garden Centre. Where it joins the lane, it's a blind corner, and it's a very dangerous blind corner. So you can't change the corner. So we have to work with what we've got. Any amount of looking at it is not going to change the fact that it's a single lane and that corner is blind. When you drive onto it, you can't see what's coming until you're onto it. And likewise, when you're coming down, I mean, I've had to slam my brakes on to avoid being hit by other vehicles coming up it. It is so dangerous. And it's become more dangerous because there's more traffic and there are more people using that footpath. It really, really can't cope with any more traffic at all. Well, you even had cars parked blocking the lane, literally blocking the lane. And I've had to ask people nicely to move their cars, and I've received abuse just so I can have access to the lane. So there are huge problems up the lane. There are no parking, there are no passing bays. All the passing bays are people's driveways, people's entrances. So you have to pull into an entrance to let another car go by. You have more than a few vehicles going both ways and it won't work. It's just so unsuitable for any extra traffic. And it's a footpath. I really don't understand why there's such a difficulty in recognising that footpaths should be protected. In the national planning policy, it states that footpaths should be protected and enhanced and encourage people to use them, encourage people to walk, encourage people to cycle. So shouldn't we be protecting this footpath? Thank you.
Thank you, Ms. McDougall. I do intend to do a number of site visits, and this is one of them where I'll be looking during the examination. So I'll be looking at it with the points you've raised in mind as well. So thank you for raising those. But is there any final responses from the council on these matters at this juncture?
I don't think so. I think everything has been said always in written documentation for you, sir.
So in terms of this, just mopping up on this allocation specifically. So you'll have seen at regulation 19 stage that the view's been expressed that that the proposal might prejudice a comprehensive development of the wider area. I think in respect of perhaps land to the north. So do you have any views on that at this stage?
The council is aware of a developer's wish to develop the site as a whole. I think any development on the site would need to be considered as a part of a review of local plan part 1 at a sort of strategic level. And local plan part 2 in this respect is looking at sort of meeting the needs of gypsies and travellers, and we can't see any reason why gypsies and travellers and settled community can't live side by side. It's in the future, if that piece of land were to come forward and were deemed to be considered suitable for development.
But insofar as I understand it, although there's perhaps an intention to seek to develop that land, there's no proposals at present, is there, the wider site?
That's correct, sir. We haven't it's not a draft allocation or allocated in local plan part 1. I'm not aware of there being any planning applications submitted for the site.
Thank you. So if we can move on to DS20, this is the old stone yard. So there's a main modification proposed to this one. Could you just take me through that one and in terms of how the proposed yield has been arrived at?
Yes, of course, sir. So when we were preparing local plan part 1, there was a pending planning application for intensification of the site. The site currently has 1 pitch on it, and the pending planning application sought to increase the number of pitches on the site to a total of 4, so provide an extra 3 pitches. At the time, we spoke to the development management officer who was responsible for determining that planning application, and they appeared to be happy with the proposals, and the application went to planning committee for consideration and was unfortunately overturned and refused. It was mostly on the grounds of the committee considered there to be too many pitches proposed for the size of the site. So taking into account the views of the committee and also looking at the draft policy that we're proposing to include about the layout and size of sites, we considered a reduction in the total number of pitches proposed to the site would be appropriate, and have reduced the number down to deliver a total of 2 pitches on site, so 1 addition to what's there at the moment. And that would hopefully deliver sufficient space on the site to accommodate things like play space, for example, amenity buildings, and just generally reduce the density of the development on the site. So that was the council's sort of thought process behind that main modification, sir.
And in terms of that, we talked about, sorry, So we talked about rebasing the base date to the 1st of April 2022. So with that in mind and this alteration to the yield, it'd be sensible if there's a consequential modification to the table. Table 4. Okay, so any views on that particularly in terms of a modification?
I don't see an issue with that. I think we are proposing to update table 4 anyway, to reflect that change in the net increase in pitches on that particular site. Yes.
So I think, yes, table 4 will need to be changed in the light of that change to the yield, which obviously takes the number that we're actually allocated for from those sites down to 15. But obviously there'll be changes also to the number of planning permissions that have been granted since 1st of April 2020, which will be reflected in the updated table. So that will actually show how many actually are required for local plan part 2.
Thank you. So moving on to main modification 80. So this is the proposed design policy. So this integrates things that were previously in supporting text. So if you could talk me through that policy, please, and what it seeks to achieve.
So the policy seeks to provide some more guidance and to prospective applicants in terms of what the council would be looking for on any new Gypsy and Traveller pitches, to ensure that there's an adequate standard of accommodation provided, and that also there's sufficient services to be able to meet the needs of those living on the site. For example, things like utility buildings and play space for younger members of the family, and landscaping and hard standing for their trailers and caravans. The policy will hopefully provide a bit more weight than perhaps some supporting text to help our colleagues in development management when they're considering any future planning applications, to ensure that those a good standard of accommodation is met on sites. I think we have in drafting the policy had regard to some guidance previously produced by DCLG, which has been subsequently removed by them, but it did set out some good practice in terms of designing Gypsy and Traveller accommodation, and so the council has sought to take that forward in this draft policy.
Thank you. I just thought in terms of that, it perhaps be useful if there's like a preamble in the supporting text. That hits the following points, so that the NPPF establishes that plans should set out clear design expectations, and that development should create places that are safe, inclusive and accessible, and which promote health and well-being. And then consequently, policy DM37 sets out design principles relevant to Gypsy and Traveller sites, or just Traveller sites, I suppose, if that's the that's what PPTS refers to them as. So, any views on that?
Yes, I think we'd be happy to insert that text. That's not a problem.
So we've talked about travelling show people yards more generally, and the potential for speculative applications to be made during the plan period. Now, in terms of that design policy, does that equally reflect the specific needs of those? So I think PPTS, paragraph 18. So it's paragraph 19. Local planning authorities should have regard to the need that travelling show people have for mixed-use yards to allow residential accommodation and space for storage of equipment. So in terms of that design policy, is there enough in there for those, for design about that type of development? I'm thinking particularly in terms of perhaps residential amenity, the safe access and highway safety aspects that might be different in terms of a travelling show people site.
So thank you. It's helpful to be reminded of that guidance, and so that there are potentially a number of differences in policy terms between what might be acceptable and appropriate for the travelling community and the requirements of travelling show people. In that respect, it may be sensible, so in fact, to have very close to DM37, perhaps DM37A or DM38 as a further new policy that's specifically tailored to those requirements. And perhaps that's something we can take away and consider with particular regard to paragraph 19 of PPTS.
Yes, thank you. So I think that'd be useful in terms of achieving that consistency with national policy in those terms, and particularly what we've said following the discussion we've had with Mr. Smith this morning. So in terms of PPTS, that requires allocations to be made for households that meet the planning definition of traveller given in the glossary to that document. But I pose the question about those that don't meet the planning definition, but nevertheless culturally they identify as traveller households. So while I appreciate that need wouldn't have to be met through specific allocations, in terms of the policies I'm thinking in terms of the HN4 and the proposed policies, DM38 and a potential DM38A, whether those policies would apply to speculative proposals for those who have cultural needs for appropriate accommodation that isn't bricks and mortar accommodation. And thinking particularly about paragraph 62 of the framework, which talks about meeting needs. I'll just retrieve it. The housing needed for different groups in the community should be assessed and reflected in planning policies.
So the approach that local plan part 2 has taken obviously comes from the work that we undertook for local plan part 1 in terms of the housing market assessment, the strategic housing market assessment. And although it did obviously identify different groups that would we would try to meet their needs through the local plan. It didn't actually identify specific needs for caravans and other types of accommodation like that specifically. I think there, obviously, the approach that we've taken is in the strategic policy AHN 3 that deals overall with meeting needs of specific groups, but I think it specifically identifies the elderly and the disabled and those who have challenges with access. However, the policy that we actually, there is no specific policy in local plan part 2 with the need that you actually recognise because of that. However, I think we would be happy to look to see if those policies with regard to accommodation could be made general to deal with those respective proposals for need where it arises.
Yeah, I think it'd be useful as the GTAA does identify some need, albeit, as I said, no allocations. It has to be made. That's what PPCS tells us. But I suppose it might just be a piece of supporting text that says that acknowledges that, but that any planning applications would be determined in line with relevant policies of part 1 and part 2. Any views on that, Mr. Ellis?
So I think we'd look at the number of options that you've obviously suggested there as a main modification.
Okay, I've got no further questions on this topic. Ms. McDougall, have you got anything final to add?
Just that you were sort of differentiating between the traffic used by travelling show people and other gypsies. But in my experience, the original person who lives there, he used to drive a really, really big lorry up and down the lane. And it was really unpleasant to stand on the side and have this lorry pass so close to you when you're standing on an uneven bank. So I am concerned about the type of traffic that would be coming up the lane. Thank you.
Thanks, Ms. McDougall. Any final responses on that or any other points raised?
I don't think there's anything from myself, no.
Thank you. So thank you for your contributions this morning. And we'll now adjourn and come back. Should we say at 11? I don't remember what it said on the program. I think, can we bring it forward to 11, please? Yeah, thank you.
Hello, hello. Hello, testing, 1, 2, 3, testing, testing. Testing. We'll all leave the room if I do that. Yeah, because he's not, yeah. That's okay, isn't it? Hello, testing, 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 testing. Testing the mic. Testing, testing the mic. Testing.
If we can open the hearing session now on matter 11. I'm GJ4, Inspector appointed by the Secretary of State to conduct the examination and to report to the Council in due course. I could ask the members of the Council team for this session to introduce themselves, please.
Morning, sir. Wayne Beglan, Council on behalf of the Local Planning Authority, and with me for this session, Miss Knowles and Mr. Ellis.
Thank you. So matter 11 is a consideration of the plan's approach to town centres and employment uses. So just saying at the outset, I'm content to take the hearing statement on this matter largely as read, but I have a handful of questions and clarifications to discuss, mainly relating to the main modifications that have been proposed. So firstly, this main modification 72 to policy DM26. So could you take me through that main modification, please, and the reason, particularly for the weighting to be accorded to educational provision?
Thanks, Sam. Main modification 72 relates to the third part of the policy DM26, which is on employment sides. The council originally proposed the wording due weight will be given to the wider social, cultural and economic benefits provided by educational and training facilities when assessing applications. However, it was considered that the word due was not clear as to the weight that should be attached to those particular matters in considering a planning application for that, and did not accord with the national planning policy framework, and therefore it proposes to reflect the wording in the framework by using the words great instead of due.
Thank you, Mr. Ellis. And then there's main modification 74, please.
Thank you, sir. So MM 74 is to clarify the second point of policy DM 32, which relates to tourism, hotels and visitor accommodation. And so the modification is put forward just to clarify that in point 2 of the policy, where it refers to any development, that's any development specifically relating to tourism, hotels or visitor accommodation. to avoid any confusion in relation to that part of the policy.
Thank you. And then main modifications 75 and 76.
So main modifications 75 and 76 are linked, and MM 75 relates to part 3 of policy DM 32. And in your MIQs, you were questioning whether the phrase incapable of improvement to a good standard was sufficiently clear, and whether it would be clear how this would be assessed and when. And so MM 75 proposes to amend that wording to say, and is incapable of being improved to allow it to become viable. And MM 76 adds an additional bullet point to paragraph 5.42 of the explanatory notes. Actually, so I've just noticed that's an error in the main modification. That should actually be an additional bullet point to paragraph 5.41, which is the explanatory notes to the policy. And that is that for the purposes of this policy, and specifically that phrasing which has been added through MM 75, that an application should submit evidence of the current physical condition of the building. If significant repairs are required, then an estimate of the cost of these, evidence of the scope of refurbishment to upgrade the current facilities, and an estimate of the cost of these, and evidence of the impact of the above on the future viability of the business. And that's to assist officers in assessing whether the development, whether the accommodation is incapable of being improved to allow it to become viable.
Thank you. So in sameness terms, that's effectiveness, isn't it? And to achieve consistency with the framework in terms of clarity and unambiguity.
Yes, we consider that it is.
Okay, so in terms of DM 32, so I posed the question about the use of the phrase in part 5 of that policy. Extensions to existing visitor accommodation establishments or attractions will be supported. So I'm still not persuaded that that's effective wording, and mainly for the reason it sounds like there's a bit of a blank check there. I take it what they said about the development plan as a whole. But I wondered in terms of that phrasing whether the framework gives us any kind of clues about how something could be worded to be consistent with that, whilst reflecting the support that's given to that kind of development going forward. So paragraph 821 of the framework talks about significant weight should be placed on the need to support economic growth and productivity, taking into account both local business needs and wider opportunities for development. So that's one point. And then in the part of the framework that specifically refers to supporting a prosperous rural economy. So paragraph 84, planning policies and decisions should enable the sustainable growth and expansion of all types of businesses in rural areas, both through the conversion of existing buildings and well-designed new buildings. So I think there's perhaps some language there in terms of sustainable growth and the well-designed aspects of those buildings. And then specifically in terms of part C of paragraph 84 talks about sustainable rural tourism and leisure developments which respect the character of the countryside. So taking those aspects together, what are your views on perhaps some amendments to the wording that could perhaps clarify and provide a more effective basis for decisions in terms of that 0.5.
Yes, sir, we'd be happy to go away and come up with a main modification to suggest some additional wording to that paragraph or part 5 of the policy, particularly to reflect those paragraphs of the MPPF, paragraph 81 and 84 in particular, part A and C of that paragraph into the policy. Yep.
Okay, thank you. Okay, I've got no further questions on this topic. As I said, taking the hearing statement largely as read. So if there's nothing further you'd like to add at this stage.
No, nothing further from the council, sir.
Thank you. So we'll adjourn now and we'll resume at 2 this afternoon for the discussion on transport. Thank you.
Thank you very much, sir.